My first time meeting Barbara Chandler was during a presentation of hers at the Newton Library. She was giving a talk to the real estate community, and it was put on by the city of Newton. After seeing Barbara's presentation, I went back to the office the next day and changed the way I train my agents. She's been a keynote speaker at some of my real estate seminars, and I'm honored to have her on the show. Thanks for joining me.
Thank you for having me here.
So tell me a little bit about your position and what you're doing. You're an advocate for fair housing. And
yes, I am. I work at Metropolitan Boston Housing Partnership, which is a regional nonprofit that serves low-income families in the greater Boston area who need housing services. It could be giving vouchers, housing search, and I am responsible for the Fair Housing Project, which is to see if we can reduce the discriminatory barriers that prevent our clients from getting housing or keeping housing.
I understand. Fair housing encompasses a number of different topics and areas. I guess one of those would be tenant screening, for instance. Talk a little bit about that.
Sure. You know, tenant screening is extremely important for both parties. So the reason it's connected up to fair housing as strongly as it is that someone's membership in a civil rights protective class, such as race, ethnicity, disability, gender, there's a fairly long list here in Massachusetts, that membership in whatever civil rights protected class is out there cannot be taken into consideration when someone is going through an application process. So we try to make sure that whether it's real estate agents who are doing screening or it's property owners who are doing their own screening or property management companies, that when they are setting up application forms, the questions that they're formulating, that none of it is going to circle back to someone's protected class membership. Because the minute that happens, then it raises the possibility that there's been some illegal discrimination that's happened.
I see. So I often tell clients, you know, you choose who you would like as a tenant, but you don't choose who wants to see the apartment.
That's correct. We sometimes run into problems where someone is being screened out at the point of just calling to say they're interested in a unit.
Correct.
Families with children under the age of 18 is a civil rights protected class on the federal and state level. What's particularly important is families who have kids under 6, because that's when the lead laws
The lead
kick
paint,
in.
exactly.
Right. So when a family calls and they said they're interested in a unit, when housing providers or real estate agents get into, well, do you have a child under the age of 6? Sorry, not deleded, go away. Then that's not only a violation of the lead laws, it's going to be a violation of state and federal fair housing laws. So you really need to let the person apply, show them the unit, and then if they will meet the terms of tenancy, then you deled. If that's an issue. But screening them out, saying, sorry, there's lead in the unit, so we don't deal with families with young kids, that's where you end up getting a call from someone like me. And when you get that call from someone like me, you're in trouble.
Barbara comes at you with both barrels. And I know this from experience. Not that just speaking at my shows. But now, for instance, when somebody calls and they're interested in seeing an apartment, and I remember this from the first time I saw you speak, and they say, I have a disability. Am I correct in saying that you cannot ask what that disability is?
That's correct. You're not allowed to ask the specific disability or the nature or the severity of the disability. And also, you're not supposed to make any assumptions about a person because of their disability. Sometimes run into situations where housing providers say, I'm sorry, I don't think this apartment's going to be useful for you because it's not accessible. Well, the issue is you don't know, as a housing provider, whether that person with a disability will be able to function in that housing or not. So you should show them the unit anyhow. Explain up front. If you need a ramp, I don't have a ramp. If you need this, and if the person screens themselves out because you don't have the acceptable feature they need, then that's acceptable. But if you're screening them out because you have a preconceived notion of what a person with a disability can or cannot do,
that person can
that person can allege
make the decision
discrimination
just like anybody else can.
That's exactly right.
And it might be a good one or a bad one. So now, on applications, what are some of the things that you've seen that are borderline cross the line as far as asking?
I've seen applications that are asking whether somebody speaks English or not. I've seen applications that are asking the ages of the children in order to screen somebody out because of the lead issues we've mentioned already. I've application forms that are asking for disability status.
Yes.
So there's been a lot of applications that I have seen that are asking for information regarding protected class membership, which should not be on an application at all.
Correct.
And I really want to caution people, because these days a lot of people download standard application forms from the internet, and they do so with the assumption that that application form must be compliant, and in most cases it isn't.
Okay.
So I always caution property owners and real estate agents that if they're going to use a form they're downloading from the internet, they should have a local attorney review it, because some of these forms are actually national, so they leave out the fact that state law may be different. So I wouldn't, and I would say the same thing about leases, is you should never download a lease without having an attorney who knows Massachusetts law reviewing it.
I exclusively use the RHA forms, which are all up to snuff.
On a lot of these forms on the internet, I would also look at, usually on the bottom there's a date that says the last time they were updated.
Of course.
In Massachusetts, that the last time there's been a change in our fair housing laws was actually in 2010. So if you're using a form that's older than 2010, you may be running into some problems where it's not as current with state anti-discrimination law as it needs to be.
Okay. Now, with regard to, for instance, a Section 8 tenant and determining affordability. Okay, can this person afford it? Sometimes the voucher pays for all of the rent. Sometimes it doesn't include utilities. Talk for a moment about that.
All right, let me take a step back first before I answer that question, because many people are not aware of that one of the civil rights protected classes here in Massachusetts is receipt of government assistance.
Okay.
So that covers persons who receive unemployment benefits, veterans benefits, SSI, SSDI, all of those things. But it also includes rental vouchers, such as the Section 8 program, which is the federal voucher, and the Massachusetts rental voucher program, which is the state voucher.
Okay.
Both programs have very different requirements.
Okay.
Obviously, if you are screening applicants, you want to make sure that whoever comes into the unit can actually afford the unit.
Of course.
And in most cases, for a voucher, the client is going to be paying anywhere from 30 to 40% of their income towards the rent, the rest to be picked up by the voucher program.
Okay.
So in determining whether this applicant who has a voucher can afford the unit, while you can't count the value of the voucher as income, you must take it in consideration.
Okay.
So in combination of whatever their actual income is with the value of the voucher, if that combines to a number that appears that they would be able to afford the unit. Different housing providers use different standards for affordability. Some places will say that you should not be paying any more than 30% of your income towards housing. Some do 40%.
Right.
When you get to 40%, I think you're getting into the rent burden.
I agree, even though, in different parts of Boston and the country, some people are paying 50%.
Yes, that is very true.
And it is a burden. The old rule of thumb, if you will, was 1 week's paycheck. And that just doesn't cut it anymore.
No.
Not even close. So, now, in and around the area of protected classes, there are, for instance, areas that, someone could say students, or lawyers, or law students, Yankee fans. They are not protected classes, and you don't have to rent to them.
That's correct. You can actually, not that I think it's a good idea, but you could screen people out based on some of those types of categories. The thing about the term discrimination is people assume that if someone's discriminated against, it's obviously illegal, and that's not true. It's only illegal if it's connected to membership in a protected class. So
or
if I decide,
has a prejudice.
Yeah, well, even that's a little...
Is it? Okay.
Yeah, that's a little loose.
Okay.
But I can choose not to rent to students.
Right.
And that is fine because students are not a civil rights protective class as of today. But if I, for instance, said I don't want to rent to someone who's 40 years of age or older, then we have some age discrimination going on here. So you have to be very careful. My recommendation to housing providers is always, if you're really going to try to figure out who's going to be low risk as a potential tenant for you, is you look at what's their past history. References, for instance, are a good way of getting at that. What is their...
Obviously, the credit report.
What's the credit report saying? Those are the kind of things that are going to give you a stronger indication of whether somebody's going to be a good tenant or not than protected class membership, or even the arbitrary categories of someone's a student, someone's a lawyer, someone's a Yankee fan.
Exactly. Well, I don't know about Yankee fans, but that's another show. Now, when it comes to, we were just talking about screening references and whatnot, the credit check. I myself, we do not get the score when we do a credit check. We treat every application the same. It goes through a standard credit check. Some people said, gee, can I provide my own? I said, nope, we treat every application the same, so there's never a question of treating one person different than another in our office. And I look more at the history of the pattern of behavior as opposed to that arbitrary number. Now, if, for instance, a Section 8 tenant had poor credit, would that be an opportunity or a reason that would be okay to not accept the person?
If they truly do have poor credit, then that is fine.
And I misspoke. Not an opportunity. That was the wrong
No,
wording.
I understood what you meant. So, the point is this. It makes sense to have standard criteria that is going to be used for every applicant.
Okay.
So whether it's a credit score cutoff or it's a pattern in a credit history, that's okay. As long as it's applied to every single individual.
Right, and you're not moving the goal line for different people.
Yes, so for saying someone who has a rental voucher has to have a credit score of 700, but someone who doesn't have a rental voucher, they'll accept 500. That would be considered discriminatory.
Absolutely.
But if there's an applicant who has a voucher, and let's say they have a credit score of 300, that is very, very questionable credit. So rejecting the person or screening them out,
and the reason I asked,
that's acceptable and that's not discriminatory.
Right. And the reason I ask is because over the last couple of years, I've heard different contradictory answers to this by different legal professionals. And one of them was teaching a real estate class, saying that no, you can't take the credit score into account for somebody with a voucher. And I said, wait a minute. And I think at one of my shows, you were speaking, and this came up, where someone had a tenant that had a voucher and was kicked off the program for violations of the program, and didn't have good credit, and that was sort of the reasoning behind being able to say, because someone says, for instance, I've had Section 8 clients come and being placed in the office, and they say, well, my credit doesn't matter because it's being paid, I'm getting assistance.
Right. Well, It does
And
matter.
yes, that's my point.
It does matter.
And I'm just saying that's why I'm bringing it up.
There's no regulation in any of the rental voucher programs that forbid a housing provider from taking credit scores or credit history under consideration.
Okay.
So, you can do it. The issue under fair housing is that it has to be done in a manner that is not discriminating against them because they have the voucher.
Used in the same manner each time. Yes.
They don't get the unit because they have bad credit, not because they have a voucher.
Of course. That's what I mean. And again, I brought it up because I've heard different stories, and I was shocked to hear the real estate professional teaching the class say, "Oh no, you can't do that."
There's a lot of urban myths out there on fair housing and what is discrimination, what isn't, which is one of the reasons at MBHP we do so many trainings. Like last year we did close to 60 trainings on fair housing.
That's more than one a week.
That's quite a bit.
Yeah.
But it's important because we get at what the laws do say, what they don't say, and more important is proper implementation so that people don't get run afoul of them.
Right.
Because again, there's a lot of people who think they know this or they're operating on somebody else's misconception, and they can get in a lot of trouble. Because fair housing laws are no different than other laws.
Right.
Even if you don't know what the laws say or your intent was not to discriminate, but you end up discriminating anyhow, you're going to be treated the same way as if you intentionally did it.
To do it.
So that's why we push the education piece as much as we do.
There's been some questions in around criminal background checks. Talk about that for a moment.
That has changed under fair housing. Last year, the Department of Housing and Urban Development came out with new fair housing guidance on criminal background checks. So they are saying that they consider it discriminatory to have these blanket rejection policies based on criminal background.
Okay.
So that if there is something that shows up in somebody's criminal background check, you have to dig a little further. You have to take under consideration things such as, was it a misdemeanor or a felony? Was it a violent or non-violent crime?
Yes.
How long ago was it? And were there other mitigating circumstances that need to be taken into consideration? And after you take those additional steps, if the person is still coming up unfavorably, then you can deny them for their criminal history. But you just can't do this automatic, something showed up on your query, you're out of consideration.
Right. I understand. Now, when it comes to the leases, again, my office uses the standard RHA leases, which are updated by the Rental Housing Association, and typically they're vetted through the AG's office to make sure they're up to snuff and compliant to the terms. Are there any guidelines in and around vouchers with regard to leases? Can an owner use their own lease or an RHA lease?
In any of the voucher programs, whether it's the state voucher programs or the federal, there is a standard lease that the program requires that the housing providers as well as the voucher holders have to sign.
Okay.
However, they do allow you to do an addendum.
Okay.
And your addendum could cover things that the standard voucher lease does not. So for instance, standard voucher leases don't cover things such as parking rules or what day the trash is put out.
Correct.
Or pet rules. So you can have an addendum that actually addresses those. However, the addendum cannot have anything in it that contradicts the regulations of whatever rental voucher program we're talking about.
I see. Okay. And, such as restricting amenities and things like that.
That's correct. Or changing the amount of rent that should be paid, or setting up terms and conditions based on protected class membership. For instance, for a person with a disability, that the property owner suddenly decides that the unit's going to be inspected every month. When they're not doing that to other tenants who don't have disabilities. Those kinds of things that show up in a lease are going to be considered illegally discriminatory and can result in complaints being settled against the housing provider.
And of course, this all falls under 93A,
That is correct.
which is triple damages
Yes.
and attorney's fees.
Well, the fees for a fair housing violation are different. So it depends on whether you're talking about federal or state law.
Okay.
So they can
And
actually
93A is a state law.
93A is the state consumer protection law.
Correct.
And that is a separate set of laws from the anti-discrimination laws.
Okay.
And so the fees, the fine structure can be very different, how terms are set up on this sort of situation. And it is possible that you can be in violation of 93A and at the same time be in violation of the state anti-discrimination law.
Okay.
So it can be very, very expensive to be caught changing a lease
Right.
in a manner that was discriminatory, as well as
Right.
being in violation of the state tenant landlord laws.
Another topic is one of my clients' favorite is lead paint. Yeah.
I mean, property owners who refuse to de-lead, property owners who refuse to even let a family with a child under the age of 6 to apply. We've had cases of pregnant women who have been evicted because the landlord
Right.
doesn't want to deal with the lead issue.
Right.
So, and sometimes property owners say, well, I don't want a kid to get hurt. I said, well, if you're truly committed to making sure the child is safe, then you will de-lead.
Right. Well, not only that, it's their legal responsibility.
It's their legal responsibility, and for housing providers who are low income themselves, there
Right.
are federal and state resources that can help you de-lead, and there are actually tax credits out there
Right.
as well. And your property values go up when you have lead-safe housing.
Correct. I've managed a number of properties. I've encapsulated, interim control, de-leaded. The attorneys below my office come up and ask me lead paint questions. So, and if the windows are updated, that's usually about 70% of the cost, depending on the home, in my experience. So, and it's not uncommon that I see my clients updating a kitchen or bathroom, doing the windows, and they don't get the lead cert. Like, what are you thinking? You've got a vacant unit, you've done the windows in the kitchen or something, and you might have to do a couple of thresholds in the fireplace. It might be $1,000 and you've got your lead certificate.
That's very true, and people don't realize that the windows are really important, because every time you open and close that window, you're releasing lead dust into the air.
It's a friction surface.
Exactly right. I mean, people think
Yes.
it's strictly kids sitting around eating paint chips.
Right, or gnawing on a windowsill.
Right, but there's a
No.
lot of lead poisoning that happens through inhaling lead dust, as well
Exactly.
as the contamination of the soil around the housing.
Okay.
Kids play in the dirt,
Yep.
put their hands to their mouth, and before
Yep.
you know it. So,
It's
yeah, lead is
the-
one of our very significant fair housing issues that MBHP is always addressing.
What about the protected classes in and around government assistance with regard to mandatory inspections, repairs,
All right.
things like that?
Again, the whole point of fair housing is that equal access to housing opportunity has to be provided to everyone, regardless of membership in a protected class. So anytime there is a barrier that is created that stops someone from being able to have that housing opportunity,
Sure.
that raises the issue of illegal discrimination, right? So on the receipt of government assistance, particularly when we're talking about someone who has a voucher, refusing to cooperate with the mandatory inspection process that's connected to the voucher program,
Right.
refusing to correct violations, all of those things will stop approval
Right.
for that person to be able to use their voucher there. So that's the barrier.
Right. That's
And
the
so it's not just like I won't rent to someone with a voucher. It's all those different steps.
Okay.
Refusing to comply with any of the regulations of whatever voucher program we're
Sure.
talking about creates that barrier to equal access, and that can be, under Massachusetts state law, that can be a violation.
Of course. For instance, when a tenant with a voucher, rents a unit, they're accepted for it. I believe your agency comes in, does an inspection. If they find code violations and the owner is unable to or unwilling to, for instance, it's not a requirement, the disposal. Let's say the disposal doesn't work. Could they just remove it? How are they required to?
It depends on which type of violation we're talking about.
Okay.
All right? Because the other thing, too, is this gets back to the amenities issue.
Okay.
If you're removing the disposal in a unit for which there's a voucher holder because you don't want to repair it, but there are other tenants in the building who still have that disposal,
Right.
then you've restricted access to amenities.
Okay.
So it's one of those things you have to be extremely careful in how you do that.
Okay.
Because it would sound on the surface, yeah, just take out the disposal and you're fine.
Yeah.
Except, wait a minute, what are you providing to other tenants at the same time?
Again, you're moving the goalpost. You're moving
Exactly right.
Yes. Okay, that makes sense. A couple of years back, I had a situation where I was managing and renting a unit in, it was like 1880s row house. She owned the condo, and we had it. I told her, I said, look, it's a 3-bedroom, 3-bathroom, even though it was on 3 floors. Typically, you're probably going to have a family interested in this. You should have it tested. We had it tested. The only lead that came back was on the basement doorway, the bulkhead. And she said, well, if we have to have it removed, that's okay. Excuse me, let me back up. Inside the house, that was the only hot spot. Outside, on the exterior window sash of the first floor, the real problem was that the house was in a historic register, and the whole, I think it was 8 units, would have had to been done. And they would have had to go through historic to get the same windows. Any suggestions?
You know, that's going to be a tough one, but the issue is this. Just because it's an historic home, and HUD actually has some guidance on this on its website.
Okay.
Just because something's an historic home does not excuse itself from the requirements around lead and non-discrimination.
Right.
So the point of the matter would be, and it's hard to do a hypothetical because it all,
I know, but
it's like it all depends.
Right. The situation is, I was stuck between a rock and a hard spot because my client was doing the right thing. She said, fine, I'll do what I need to do. We had it tested. She took my advice, and but if it came to it, it would have gone to the condo association, and all the other owners would have had to comply. Then it would have went to the historic committee.
Not necessarily true.
Okay.
Because when you were talking about a lead-safe unit, you were talking about the unit and common use areas. So that if the other units did not presently have a child under the age of 6 living them, there would have been no requirement that automatically would have leveraged that to happen.
Okay.
Now, I know on historic homes there's always the issue of consistency, that you don't get to change one part of a building without changing the other.
Correct.
That's a different story.
Right.
And that's going to be out of, to be honest with you, the purview of what the lead laws and fair housing is going to say.
But they don't care about that.
Well, I don't want to say we don't care about it, but it's a very complicated question, and it would require a lot more. I would have to have a lot more access to information than I do right now to say this is what would happen, this is what would not happen.
Okay. Well, that just about wraps up this show. We, again, want to thank you, Barbara, for joining us here, and hope you all come back and see us again.